when you have commercial motor vehicles or company-owned vehicles, they tend to be bigger and can produce bigger impacts, bigger injuries. A lot of the cases that we have are beyond just Uber and Lyft. We need to establish that FedEx or Amazon is controlling what the driver does or overseeing what the driver does. When we have companies like Uber Eats and DoorDash, that's a different ballgame because they're not taking a person from point A to point B, they're taking a product. Those companies are going to have multiple layers of coverage that protects them from big injury claims. Witnesses go away, video goes away, and so time is of the essence. When you get that police report, you're gonna find a company owns this vehicle. A lot of the times they're not forthcoming with the insurance coverage that's available. Sometimes we have to go through the court to force them to give us that coverage information. My name's Sam Powers. I'm an attorney at Morgan & Morgan, specifically litigation attorney in the Diamond Pod in Tampa, handling catastrophic injury and major commercial motor vehicles and trucking.
Personal injury cases hinge on the details. ABC Legal, America's most trusted process server, simplifies every aspect of service, so you can focus on winning your clients' cases. ABC Legal-empowered process servers deliver documents nationwide and make 12 million attempts annually, with real-time GPS-tracked updates and proof available online. ABC Legal's simple and transparent services make life easy for your team and help you keep costs under control. Your clients deserve consistent, reliable, and accountable service of process. Sign up for a free account today.
Commercial insurance cases typically revolve around company-owned vehicles. So when you have company-owned vehicles, they're going to have commercial motor vehicle insurance. And when you have commercial motor vehicle insurance, that typically means there's going to be more coverage than just an individual who owns a vehicle isn't going to have the same level of coverage available on their insurance that a commercial motor vehicle or a commercially owned motor vehicle will have. So that kind of affects the dynamics of a case and the value that that case can have. It can range, from $300,000 to millions, multi-million-dollar cases. It all depends on the severity of the crash, the severity of the injuries, and what a jury eventually would put a value on those injuries and that crash. When we have commercial insurance policies, it just means that there is more insurance to cover those severe crashes and those severe injuries. So the complexity with these cases are kind of twofold. When you have a company involved, there's going to be more issues with employer-employee relationships versus independent contractor relationships. Usually, a company owns a vehicle, they have a commercial motor vehicle policy on that vehicle, and they've got another driver driving it. And whether that driver is an employee or an independent contractor, that can become a major issue in our cases. But typically, beyond that, when you have commercial motor vehicles or company-owned vehicles, they tend to be bigger and can produce bigger impacts, bigger injuries, and that can make the case more complex just by virtue of the complexity of the injuries. Broken bones and death and those certain things can make a case more complex from our standpoint. When we're identifying these cases, typically the first thing we get is a police report, and that's going to have the information of the vehicles on it. And when you get that police report, you're going to find a company owns this vehicle. Now, we're not going to have that insurance information right away. However, when we identify it is a company-involved vehicle that has injured our client, that tips us off that there is probably going to be a commercial insurance policy on that vehicle, a larger policy, usually $300,000 and above. And so when we see that, we know that there's going to be that policy to recover money from, so we can spend the money early on to do the proper investigation of the crash by getting an investigator to the scene, getting witness statements from third-party witnesses at the scene, canvassing the area for video, potentially from local businesses that shows the crash. That way we can lock in liability for the crash early on and continue the case forward from that point. Because witnesses go away, video goes away, and so time is of the essence early on. When I talk about canvassing a scene, there could be gouge marks in the roadway, and those go away over time. Video gets deleted by local businesses that surround the area that potentially could show the crash. Witnesses move away and they sometimes are unable to be located. So when we identify the commercial policy early, we know that we can go and send out these people to do this investigation early before we potentially lose all that crucial evidence. And so that is why identifying these policies early is so important, so we can get that crucial evidence before it potentially goes away forever. The client should be made aware early on of a commercial policy being in effect simply by virtue of the fact that a lot of the times they're severely injured and they need to see a doctor, but they don't have health insurance or they don't have a way to pay for that medical treatment. And we can send them to doctors that will forego payment early on, and a lot of the times they're not aware of that. And so they need to be made aware that we have this policy available to us that will pay for their medical bills and their injuries later on. By virtue of explaining that policy to them, they feel a lot more comfortable, spending the time and effort in getting to a good doctor and potentially spending the money to treat their injuries. Early medical treatment is so important because that documents the injury claim. Somebody can talk about how an injury has affected their life and how bad of an injury it is, but when we don't have medical records that are laying that out and being presented to a doctor, it just makes it harder to prove an injury case. So we always want early medical treatment to document the injury, diagnose the injury, and figure out exactly what that injured person needs in order to get better and to find healing on their injuries. So getting that early medical treatment is vital in documenting the claim and making sure that that person gets the treatment that they need. A lot of the times with company-owned vehicles or commercial insurance policies, they typically only give us an inkling of the coverage available. And sometimes they have multiple layers of insurance coverage available through a variety of different insurance companies. And so there are things called excess insurance policies and umbrella insurance policies that will cover them beyond just their initial layer of commercial insurance. And sometimes it's a battle trying to uncover that additional coverage that could pay for the serious injuries that have been forced onto our clients unnaturally by a motor vehicle crash. So finding those excess layers and those umbrella coverages is very important to do. And a lot of the times it's not immediately obvious. A lot of the times they don't give us that right away. So we have to dig to find those excess and umbrella policies that may be available. Before we settle any case, we have companies fill out insurance affidavits, which essentially requires them to tell us exactly the insurance coverage they have under oath. And so we would have them fill that out in any case prior to settlement so that we know for a fact what they have. But sometimes we're not in a position to settle a case. And so we need to figure out that coverage because the injury claim is worth more than what the coverage they do have, or at least that they've revealed to us is. And so we have to find that coverage in other ways through discovery, through litigation, and sometimes we have to go through the court to force them to give us that coverage information. So everybody's heard of Uber and Lyft and DoorDash and Uber Eats and Postmates and all of those types of companies that not only transport people but transports goods like food and groceries. And we find that because there are so many of those companies and so many of drivers driving for those companies that they are causing a lot of crashes. And so we have a lot of cases that involve those ride-sharing companies or those delivery companies. TNC is a transportation network company, and that's what the statute defines it as, a ride-sharing company. So a company that is taking a person from point A to point B. And so in Florida, those companies are protected by the statute, and they are automatically an independent contractor in those situations. And so Uber and Lyft will not necessarily be involved in the litigation. However, their commercial policies still apply to the drivers of Uber and Lyft. Typically, Uber and Lyft, they have a $1 million commercial policy. The requirements may be lower, but what we usually find is a $1 million policy on the Uber and Lyft drivers. And again, that just goes to the whole point of that provides us with the coverage necessary to cover the vast majority of the injury claims we have. With Uber and Lyft, when they are hiring drivers, they're not telling them, hey, you only can drive for our company. You can drive for other companies, and you get to choose your hours. And essentially what that is doing is saying, hey, we don't control what you do and when you do it, and therefore you're not an employee. That statute just lays out the factors that the Florida law considers when determining whether or not the driver is employed by a TNC, a transportation network company. So as long as they're not telling them when they have to drive and that they can only drive for Uber or they can only drive for Lyft, typically they're going to be covered under that statute and protected by Florida law. For the ride-sharing companies, the Uber and Lyfts, at least in Florida, they are protected by a Florida statute, which essentially lays out that the drivers are independent contractors rather than employees. And that's very important under the law in establishing something called vicarious liability, which allows us to put blame on the company rather than just the individual driver. And so in Florida, with Uber and Lyft, their drivers are protected under the statute from being employees, so we can't get to the Uber and Lyft company or companies and establishing liability on them. In order to establish vicarious liability between a driver and an owner, you have to show that they're an employee rather than just an independent contractor. And the overriding principle with that is how much control does the company have over their employee, the driver. And so a lot of the times in these cases, we need to establish the company is controlling the driver and what he does or what he or she does throughout the day and where she goes and how she goes about driving the company-owned vehicle. Establishing the employee-employer relationship is all about control. And a lot of the cases that we have are beyond just Uber and Lyft, but with DoorDash and Uber Eats and Amazon's and DHL and FedEx, we need to establish that FedEx or Amazon or Uber Eats or DoorDash is controlling what the driver does or overseeing what the driver does. And so in cases that we've had with Amazon hires lower level companies to help deliver their packages because there's so many people on Amazon that they can't do it all themselves. So they hire essentially middlemen companies to help deliver all their packages. Now, when we sue Amazon on those cases where an Amazon driver injures one of our clients, we need to establish that Amazon is the one calling the shots. They're the ones that are directing the drivers, that are overseeing the drivers. Throughout litigation, we're able to conduct discovery, and we're able to get documentation showing that Amazon is tracking the drivers step by step throughout their route. Now, Amazon hires the lower level company to deliver the package, but Amazon is still controlling everything that lower level company does. And in litigation, we found that not only are they controlling where they go and what times they work and what they do, but they're also tracking them step by step. And so we've gotten through discovery data that they collect where the drivers are being tracked at every second of every day, exactly where they are based on longitude and latitude and how fast that driver is going. And not only do they track exactly where they are, but they also have metrics that show sudden stops, hard left turns, excessive speed. And so all of that helps us establish that this is not the lower level company that is controlling this driver. It is truly Amazon that is controlling this driver. And that allows us to establish that vicarious liability on Amazon and potentially get a judgment against Amazon rather than just the small level company in between. So when we identify that a big retailer is involved and we establish that it's not the transportation company that they've hired that's calling the shots, it's Home Depot, it's Amazon, it's Walmart, we get to put them on the verdict form. They are now a part of the case. And so when we have those big companies, jurors aren't worried about, what this verdict is going to do to an Amazon or a Walmart or a Home Depot, because they have the assets, they have the resources to pay it. And so it's vitally important to bring those companies in not only from a jury verdict standpoint, but just from a insurance policy availability standpoint, because those companies are going to have multiple layers of coverage that protects them from big injury claims like we have in our firm. There are a variety of ways in uncovering the coverage that could be available in any case. We have requests for admissions, where we request that they admit or deny certain allegations that we can make. We have interrogatories, which are written questions, where we simply ask, what is all of the insurance coverage available to this company or to this driver? We have requests to produce, where we are requesting that they produce all of the insurance policies that they have that are available to cover the claim, the injury claim that our client is making. Now, what we have found is that a lot of the times they're not forthcoming with the insurance coverage that's available when we request them through the discovery process, through the request for admissions, the interrogatories, the request to produce. And a lot of the times we got to go in front of a judge and we have to move to compel that they provide us with all of their insurance coverage so that we know what the insurance coverage is available. And a lot of the times we found that they tell us under oath initially there's a certain coverage that exists, and we find out later that there's more. And then we go down another road where we're moving for sanctions against the companies because of their lack of truthfulness in their discovery responses. When a company is involved, they typically know that they have insurance or they have assets to cover any type of verdict that they award. So they're not worried about John Smith if it's just an individual that's being sued or an individual that's the defendant in the case. They might be worried about John Smith and what that verdict could do to him. When we have large companies like Uber or Lyft or Uber Eats and DoorDash and Amazon, they typically don't have those same types of feelings. And so they're more willing to give a just verdict on a case and not worry about the financial obligations of a defendant in a case. There is a flip side to it. So in trials in the past, we have heard jurors that have said in jury selection, we're just here because there's a big company involved. And so it's vital to get that out in jury selection, find the jurors who feel that way, that the only reason we're here is because there might be a big deep pocket via the company that is involved, and eliminate them from our jury panel, because those are the types of people that we can't have in our jury. This aspect of law is interesting to me because we get to help people, and we get to help everyday people. We're not working for big companies or big insurance companies. We're working for injured people and injured people who don't know where to go next. And so Morgan & Morgan was really the place to help the most people. And so that's why I got into this area of law. We have the best attorneys, and we are going to give you the best representation that you can find. We have the resources to truly litigate your case and get the maximum value that we can. Because we have the vast resources that we do, we can spend the money that we need to on investigations and experts and trial prep, and that puts us in the best position to maximize the value of anybody's case.